Our first presentation is going to be from Hunter Dorwart, who is an independent researcher in the US and a law student at the George Washington University Law School, looking at platform regulation from the bottom up, judicial redress in the US and China.
All right, hello everyone, how are you doing? Privacy and cybersecurity are two notable aspects of platform regulation, particularly when it comes to data management, governance, and security. As professional fields, they both have incredibly long and complex histories and have been characterized by tons of academic debates regarding how government institutions and private entities collect, process, and share data. These functions are particularly important when it comes to the digital economy and the range of services it enables, such as e-commerce, cybernetic industrial systems, logistics, connected devices. We all know the drill with the big data ecosystem. But in recent years, we've seen the emergence of data protection regimes in both the US and China. Complex history goes back well beyond the computer age in both countries. But in recent years, say the past 10, but in more focus 3 to 4, there's been a lot of emphasis on countries developing their own data protection regimes and the components of that and where things play out. So these regimes are often framed as top-down architectures that complement other centralized regulatory mechanisms. So we see, for example, laws, such as with the PIPL in China, the data security law, but also a range of state laws in the US, regulations that take on sectoral characteristics, such as regulatory guidance regarding connected cars, how data is shared between cars, mobile apps, children's privacy, smart cities, and so forth. And we also see a lot of topics on standards and what the private sector is doing and how this interacts with government regulations both in the US and China. So while we have a lot of this conversation on the top-down architecture, we also don't have that much regarding how individuals may regulate platforms from the bottom up. And that is by vindicating claims in court as private litigants. Data protection links up to other regulatory models because it sets expectations for commercial and governmental behavior to pursue various ends, whether they be upholding privacy as a fundamental right or ensuring a level of consumer protection in the digital age. So I had some preliminary questions when I wanted to say, well, how exactly in the US and China can individuals affect platform regulation? Some questions I had were, does this process have a measurable effect? And are there any limitations to that? If so, what are the institutional mechanisms that structure the process? Are there any barriers? And will courts play an active role in the emerging regulatory ecosystems of both countries? So the scope of my research is I examined a bunch of data protection litigation in both the US and China. There's lots of data from both countries. The jurisprudence is quite complicated, not the least because the function of the judicial system varies considerably between the US and China. One important aspect of the research was to contextualize the developments in litigation with the larger administrative, regulatory, and operational goals of both countries. This includes not only national strategies with respect to data protection and cybersecurity, but also the implementation of these strategies through concrete administrative mechanisms. So important here is how platform regulation from the bottom up complements the top-down model. And if so, what are the connections between these two layers of regulation? So before we dive into the substance of the research, I wanted to spend a minute on the methodological limitations of this type of comparison. Comparative law suffers from a range of difficulties, not the least including transplantation issues or the problem of taking a legal system and its history and culture in one context and superimposing that on another context or another model. And this is particularly difficult when it comes to a political and legal system as unique as China's. Lawyers trained in the US and Europe have their own pedagogical influences and their assumptions about how the law works and how government is supposed to operate. This is a big limitation, which leads me to the second notable problem is that how can we have an objective understanding of how the law works without a neutral model through which to compare variance with things? And I refer to this as a observer effect or a self-referential problem. With cybersecurity and privacy and data protection, there's a bunch of other problems because there's a lot of historical complexity and, you're addressing narrow questions and a range of information. And also a lot of this stuff that I'm going to share with you guys tonight, they're inchoate trends. They're just starting to take shape. They're just starting to emerge. But nonetheless, I think that we can have a good sense of where we're going with this. And I wanted to throw this slide in at the beginning for you guys so you can understand where I'm coming from. So what are the kind of main takeaways of the research? Well, first, litigation is increasing rather rapidly in both countries. This may be reflective of the embeddedness of the digital economy in our lives, the fact that we're witnessing more harms when it comes to data protection and privacy. In the US, courts traditionally play a more active role in affecting social policy and regulation. People commonly call the system more litigation friendly, and it's served to some degree as a mechanism through which regulation has come into being. With data protection, right now, there are notable barriers preventing substantive change from the bottom up, but the trends point in having those barriers slowly kind of dissipate. In China, by contrast, litigation will play a less active role. In terms of the large platforms, the central government will serve as the primary regulator, as we've seen from other colleagues with this conference. But as we will see, this doesn't mean that the court system will do nothing. In fact, there are many notable developments that may complement regulation from the top up that we should be aware of. So I wanted to, yes.
Hunter, could you speak just a little bit slower so the translators can keep up with you?
Oh, absolutely. I'm sorry. Okay.
That's okay. Thank you.
Yeah. So I wanted to give you this image first. This is what I call the dynamics of compliance behavior. And it's just a way to understand how litigation affects corporate behavior, company behavior. So you have the risk of litigation, the risk of a lawsuit. And as that increases, companies are faced with the choice of how do they internalize the cost? How do they respond to it? If it's something that can be dealt with relatively easily, such as through paying lawyers to litigate the case and the law is kind of on their side, then maybe they just, they're not worried so much about it and they don't change their corporate behavior. But if the money is too much, if it's actually significant, the risk, they'll again adjust their compliance protocols and strategy to adjust for this, which then leads to advocacy and government affairs teams and lobbying efforts to either substantively change the law or get more clarification of the law, which then leads to the solidification of the law. And once the law becomes solidified, you have either an increased litigation risk or a decreased litigation risk based off of that structure. So this is just how I'm approaching the question of how litigation actually affects platforms and how it affects their thinking and their decision making. And I hope that when we actually look at some cases, that will become clear. So what is the state of data privacy litigation in the US? Well, it's a long and complicated history, but it's entering a new phase. You have a lot of different causes of action. So you have torts, but you also have sectoral laws that provide statutory rights. So claimants can come into court and directly say that the government, or not the government, but a company or the government abridged or violated my rights under the law, and seeking judicial remedy for that. But there's a lot of hangups in procedural challenges, and we're going to examine one of them, Article 3 standing, but we also see it in other aspects like class action certification and also pleading requirements, which is essentially a requirement that if a defendant can show that you haven't met a certain standard of how you plead your complaint initially when you get into court, the judge in the court can just dismiss the case. And now it's so the major hurdle for platform regulation from the bottom up is Article 3 standing. This is a court-created standard that all plaintiffs must meet to get into the door of federal courts. And one of the requirements of this test is you have to show a particularized and concrete harm. And what this means is that I go into court, I say I've been harmed by a person or a company, and it happened right now, like I've actually suffered the harm, or I'm going to suffer it incredibly shortly, that is predictable, and it's concrete. And so the difficulty with abuses to data when we talk about algorithms, when we talk about these processes, is if you can't show monetary damages, you can't get into court in the US. And courts have varied on what they require for this concrete harm standard. There isn't a uniform test across the different jurisdictions in the United States. There's currently a very high threshold for claims. It's hard to prove concrete harm when it comes to data practices that result in a harm to an individual or even a company. We have a settlement in some cases, dismissal in most, but the future trends may bring more complexity. So there's currently a split in the court system in the US that differs on how they define what concrete is. For some courts, as long as you can show that there was a risk of having your data misappropriated in a data breach context, that's sufficient to get you in the door. And now you can debate and litigate the claims on the merits. But other courts have a higher standard. They say the risk of abuse alone isn't enough. You actually need somebody who takes data to use it in a harmful way. There has to be a concrete financial monetary harm. And we're seeing that this circuit split, which goes back to the early 2010s, is still in effect, even though there's been multiple attempts for the Supreme Court to address the issue head on and provide more guidance. But they have declined to do so on multiple occasions. Although I will argue that in some of these opinions, you can see that some of the justices are more sympathetic to having data protection claims pass this Article 3 standing challenge. But notwithstanding this barrier, privacy litigation in the US continues to increase in both scale and frequency. The costs of litigation are increasing for companies under sectoral and state laws. We have a handful of laws in the United States that are being passed. No federal law yet, which has complicated things. But certainly, at least maybe a year or 2 years from now, many of the cases that are being brought under these state laws will come into court and we'll have more information. So now let's shift over to China. China's data protection and privacy litigation is also very long and complicated. Within different areas of Chinese law, at different times, there have been privacy provisions introduced, and claimants and plaintiffs have gone into court to sue people for these claims. Some novel changes within the data protection regime, the PIPL, the Personal Information Protection Law, and the Civil Code have expanded data privacy and protection rights. These laws augment an ecosystem of sectoral laws and regulations, reaffirm the top-down model, but now the question becomes, how will these pieces of legislation interact with the courts in China? And I wanted to offer a little primer on the Civil Code. There was a long compilation process, went into effect 2021, and notably it contains a new chapter on data privacy and protection, which is pretty unique because China is one of the only countries in the world that has these chapters in a civil code, and something that definitely privacy professionals and regulators have kept their eyes on. So what we see with the Civil Code, the reason why it's important is because it applies across industries in both civil and commercial matters. Rights belong to individuals as natural persons, regardless of your status, regardless of what specific laws are saying, but it can be superseded by more specific laws. And this is also subject to important exceptions and limitations that I'll address very shortly. We see with the Civil Code a hybrid between privacy and data protection as understood in European law. Some of the concepts refer to confidentiality and the intimacy of private life, while others refer to fair information practices and what companies should do to monitor data. So the Civil Code contains some key definitions and key concepts that we see in other data protection regimes, also in Chinese laws and regulations, such as the PI specifications, the Personal Information Protection Law, some aspects with the cybersecurity law as well. We're starting to see an ecosystem of definitions that are harmonizing, but also are reflective of other trends across the world from a global privacy perspective. And I've laid some of these out here. When it comes to cybersecurity and information security, some of these standards are a little ambiguous in the code and need more clarification, but we have laws like data security law that will kind of at least situate what the code is going to say, or at least be superseded by it if it needs to. There are important exemptions to these rights and these provisions and obligations for companies. One of them is consent. The other one is public information, which, it's like you think about how China handled COVID-19 and the success it had in handling it. we can see how an exception like this would work to function in that way. So I think that the policymakers are being forward thinking when it comes to this, but with exceptions, data protection laws around the world, there's always debates as to the meaning and the scope of that. So we have rights of the data subject that you can bring in court directly. You don't have as many standing and procedural challenges as you would, but there might be some cultural challenges that don't get accounted for because, again, people assume, coming from an American perspective, that you're going to have a bunch of people filing cases and being litigious and all of this, which doesn't apply to China. Complements the PIPL and PI specification and other standards. So what do we see with actual data protection litigation in China? Well, there's a lot, and it's been increasing. We have instances of cases being brought under the criminal law, instances of cases being brought under the civil code, even in recent months. I mean, one case was decided not too long ago. I was able to find about 50 to 100 cases detailing this. Sometimes the court said the right was violated, sometimes it didn't. Of course, in a civil law system, the interpretations and the judgments aren't binding as they are in a common law system, but you still see a broad array of things. One really important aspect of this is this new trend of the civil public interest litigation. So what this is it's prosecutors bringing civil cases to more serious and big time players, because many of the cases that I did find under the civil code were small time businesses. It's like disputes between neighbors or somebody setting up a camera in a private area and recording things. It's not these big platforms that are being brought into court and being litigated. With civil public interest litigation, it's taking it the step up. But the cases I found so far have actually gone after organizations that are exploiting the big platforms. They're taking advantage of either security laxity or some type of database that they get their hands on. One very famous case, the facial recognition case with the zoo, also brought under consumer protection law and some contract law, and the Supreme Court of China will formulate judicial interpretation of these provisions soon. So what are the notable trends and conclusions of this research? Well, the first is that essentially we see data protection litigation in China increasing under an assortment of claims, mostly focused on small scale interpersonal disputes. But with the civil public interest litigation, there might be a tendency to increase the level. The central government is still going to be the primary regulator for large-scale platforms. The Chinese judicial system isn't designed to kind of facilitate that policy change. It's more of a reactive thing that I see. I don't have an expectation that the court system will be a huge driver, but it may help generate public appeal for data protection and resolve smaller disputes. And this is very notable, because when Western scholars approach China, they need to rethink how they approach the regulation. The laws and the proceedings are evidence that the central government is taking the problem seriously. While the new laws and regulations will serve as a benchmark of compliance, they don't initiate the broad changes, but we're more reactive to them. It's like evidence that there's going to be a policy change from the top through these informal networks and these other mechanisms across the interagency in China and through administrative departments. And finally, I'll just put this slide back up to show the kind of key comparative takeaways here. Many things I've indicated. The US, I think we're going to see more litigation in the future against these private companies, bigger platforms. In China, less so, but as with all comparative analyses, it's important to identify the similarities and the differences, but it's incredibly important to really appreciate well with intellectual vigor the differences in the regulatory and political systems and not fall back to assumptions about how these models work. So thank you.